Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Late last night, in the middle of a stream I was doing with the Tilted Lawyer, we had some breaking news that the Wayfarer parties have filed a motion to compel documents from Vanzan Incorporated. Now, if you remember, Vanzan, which is lovingly referred to in this community as SHAM, is a shell company that was used by Blake Lively and Ryan Reynolds to obtain text messages between Justin Baldoni and the other Wayfarer parties relating to their smear campaign allegations. Vanzan Incorporated versus John Doe's 1 through 10 was used to serve a subpoena on Stephanie Jones, who then seemingly handed over communications without a fight. So the Wayfarer parties were never notified that their text messages or access to any of their communications was being given to Blake Lively. Now, there are proper uses of a John Doe lawsuit, but this was apparently not it. Vanzan was suing for something relating to breach of contract or something along those lines, even though Vanzan never had anything to do with Justin Baldoni, Wayfarer, or anyone else involved. They used John Doe's 1 through 10, despite the fact that they actually knew the identities of all of these supposed defendants. And they then obtained everything off of Jennifer Abel's old work phone, which was in Stephanie Jones' possession, after Stephanie Jones had apparently already told Blake Lively and or her publicist, her people, whatever, that Jennifer Abel had text messages of a negative nature that they might want to see. Remember, Leslie Sloan, Blake Lively's publicist, is alleged to have bragged about that to Melissa Nathan the same day that Jennifer Abel's phone was taken. Here's the letter motion to compel filed last night. Note that this was filed in Stephanie Jones versus Jennifer Abel and not in the Blake Lively versus Justin Baldoni case, because they are looking for communications between Vanzan and Stephanie Jones, basically to prove that this was all a sham. Jennifer Abel respectfully moves for an order compelling the production of documents from non-party Vanzan Incorporated in response to a document subpoena served by Jennifer Abel on April 21st, 2025. So that was a couple months ago. They served Vanzan with a subpoena to see these documents, and Vanzan still is refusing to produce any of them. Abel's claims against Jonesworks LLC and its principal, Stephanie Jones, center on the allegation that in August 2024, just prior to Abel's scheduled departure from Jones' employ, Jones seized Abel's cell phone and accessed and downloaded the contents. In anticipation of litigation against Abel and the other Wayfarer parties, Jones collaborated with Blake Lively to contrive a mechanism for Lively to obtain the data that Jones had pirated from Abel's phone and cloud accounts, including confidential and privileged text messages, which are the centerpiece of this dispute. This was accomplished through a subpoena issued in a sham action captioned Vanzan versus Doe's 1 through 10, filed in the New York Supreme Court on September 27, 2024. Abel is informed and believes that the Vanzan is a shell company owned or controlled by Lively and or her husband, Ryan Reynolds. The facts speak for themselves. The Vanzan complaint asserted only a bare-bones breach of contract claim, bereft of factual allegations against 10 Doe defendants who, although parties to an allegedly breached contract with Vanzan, were never named or served. There is no conceivable link between Abel and Vanzan or the unspecified contract that the Doe defendants allegedly breached. In other words, Vanzan had no discernible need for the information Jones obtained from Abel's cell phone. After the Vanzan subpoena's return date, the Vanzan action was dismissed without any other proceedings and without ever having requested the assignment of a judge. The Vanzan subpoena opened the door for Lively to obtain the documents Jones extracted from Abel's phone without notice to Abel or the Wayfarer parties against whom Lively intended to use the information. Lively produced at least some of the information during discovery, confirming that the sham Vanzan action was successful in facilitating the transfer of Abel's data to Lively prior to the filing of Lively's claims against Abel and the Wayfarer parties. Lively's lawyers have publicly acknowledged and defended the sham Vanzan action and subpoena, declaring that there is nothing untoward here, just conscientious and thorough investigation, and characterizing the Vanzan action and subpoena as common tools that are entirely lawful and appropriate for pursuing claims and uncovering the identity of unknown perpetrators of unlawful activities. Arguing the ends should justify the means, Lively's lawyers admitted that the Vanzan action and subpoena enabled them to access Abel's text messages. Such tactics are hardly common or appropriate, whereas here the lawsuit is a sham, the subpoena is intended to obtain information irrelevant to the proceeding in which it was issued, and most egregiously, the purpose of the subpoena was either to obtain privileged and confidential information without notice to Abel, or to cover up Jones' prior disclosure of Abel's confidential and privileged information to Lively before the subpoena was even served. Abel remains in the dark as to whether Jones actually produced documents in response to the Vanzan subpoena, or whether the Vanzan subpoena was merely a smokescreen to conceal Jones' prior disclosure of Abel's information, the conduct at the core of Abel's claims. Abel has now subpoenaed Vanzan for documents relating to the Vanzan subpoena and release of Abel's stolen information to Lively. Abel's original subpoena included 11 categories, During the meet and confer process, she agreed to withdraw 6 of the original requests and substantially narrow the remaining 5 requests. Vanzan has rebuffed this overture and refused to produce any of the requested documents. Abel now seeks an order compelling the production of documents responsive to 5 of the 11 requests set forth in the subpoena. So here's what she's asking for. 1, a copy of the Vanzan subpoena served on Stephanie Jones in the SHAM lawsuit. 2, the documents Jones produced in response to that subpoena. 3, communications between Vanzan and Jones and or their respective counsel about the Vanzan lawsuit. 4, documents sufficient to show Vanzan's organizational structure. And 5, documents sufficient to identify Vanzan's shareholders. So they're basically going to have to show that Vanzan is a real and functional company. Good luck with that. As you'll recall, Stephanie Jones had no problem somehow getting that subpoena to the Daily Mail and Page 6, and her lawyers had no problem going on Hot Mic with Billy Bush to say, hey, this isn't a weird thing. This is a normal tool used in regular lawsuits. But they still have a huge problem, after all that, with opposing counsel seeing the subpoena for some reason. Why is that? The 5 requests at issue, as modified, are narrowly crafted to reach documents relevant to Abel's claims that Jones misappropriated confidential and privileged information from Abel's confiscated phone and accessed Abel's cloud accounts to monitor Abel's activities after Abel departed from Jones in violation of the federal wiretapping statutes. The requests are also relevant to Abel's allegation that Jones relayed the data she obtained from Abel's phone to Lively prior to service of the subpoena, and that the sham Vanzan action and subpoena were devised to allow Jones to hide behind an allegedly lawful subpoena. Vanzan's organizational documents and documents identifying its owners are relevant to show whether, as Abel alleges, Lively and or her proxies own or control Vanzan and were participants in a scheme for Jones to transfer the information through a sham complaint without notice to Abel or an opportunity to object. Well, it seems like Vanzan is going to continue to fight this and not turn over any documents. I don't think they're going to win this one. This information is obviously relevant to Jennifer Abel's claims. All right, that's all I got for now, guys. Thanks for watching, and I'll see you all soon.